water, etc. So I think that, feeling that injecting this contaminated water, which isn't just, have byproducts of oil production, it also has chemicals and substances that are deep in the earth and that stay there for a reason. There's radioactive substances, there's lead, there's, multiple other contaminants that are deep in the earth that don't come to the surface to our drinking water. The EPA has sent letters to the oil companies and to DOGGR telling them that some of the aquifers are contaminated and that those are aquifers that we could use in the future for our drinking water. I think feeling that this is really a contained, water that is basically full of contaminants doesn't really speak to what is being found by people who do this kind of research. And Stanford University recently came out with a study in this year stating that in the future we'll be using these very deep sources of water for our drinking water. And so I think with climate change and consistent drought conditions, I just think we need to protect all of our water. And I also think that we would be much further along in terms of more sustainable energy sources if it wasn't for the oil company really kind of, telling us that we really need oil when really we could be switching to more sustainable sources of energy that would help the world.
Do you feel like the county is doing a good job representing your group and defending this ballot initiative?
I think we're a team, and I think we bring different strengths to the table. I feel really good about intervening formally with the county to defend Measure Z, and I feel very good about, I'm a Stanford graduate, so I really feel good about the Stanford Environmental Law Clinic, who brings just a breadth of experience, the Center for Biological Diversity, amazing Robbins Kaplan from Los Angeles. They've really created a team that is defending Z in the best way possible.
Measure Z was promoted as a fracking ban, but within it does have no new wells after a certain period of time. And I feel like a lot of people thought that was deceptive. That's what the royalty owners told me here today. Why was that added in?
No new wells. Well, it's just the same thing about curtailing, non-sustainable sources of energy, and a lot of people talk about the fracking, but really, oil is obtained in a way that is in the way that it's found in the earth. So if water injection methods work, that's fine. There has been fracking that's been done in South County in the past, and it could be done in the future. So adding fracking is a very reasonable thing. I think the conversation to voters, which I did for many months, was really stressing that and water. We were very clear about how these water injection wells are created and how they're really not safe. And so they clean 30% of the water. There's new nanotechnology that's out in terms of cleaning this type of water. So I think that the oil company is saying that it's the cost is prohibitive. Well, the cost has been prohibitive for a lot of things in the world, and but we have to do it. Yeah.
Thank you so much.
Oh, thank you.
All rise. Here in Court of Monterey County is now in session. The Honorable Thomas Wills presiding. You can see.
All right, good afternoon. We will resume. Z trial.
Good afternoon, Your Honor. Savannah Fletcher, speaking on behalf of Protect Monterey County, the interveners in all 6 cases. Just to quickly pick up on some things you asked me yesterday, a quick citation that I didn't have ready yesterday related to new wells. If you'll just write down Administrative Record 364 is what I was referencing. But moving on to the question,
You referenced.
referencing new
discussed
wells.
many things.
Yes, sorry. When we were discussing new wells and how to interpret what the prohibition against new wells should be read.
And that says what?
And that is an argument in favor of. It was not in the language of the measure itself, but rather it was a finding that explained that the prohibition against new wells does not include reworking or redrilling existing wells. And that was before the voters, when they voted on this. Moving
You
on.
agree that Measure Z does not contain in what we call segment 1, well stimulation treatment section, any reference to how or where the line is drawn between well maintenance and well stimulation treatment.
What this, no, in response to well stimulation treatment, that is defined within the measure following how other state regulations define well stimulation treatment. But the citation I'm providing is hoping to clarify how new wells are defined within Measure Z.
But doesn't the State Department of Oil and Gas and Geothermal Resources have thresholds which it enacted after study as to when the use of acid in well maintenance would be considered maintenance and when it would cross those thresholds and become a well stimulation treatment?
The distinction that Measure Z lays out is the intention to use well stimulation treatment for further production compared to whatever well maintenance treatment is required.
Well, how do you determine? That's my question. Measure Z does not contain language that distinguishes where the line is between the use of acid for well maintenance and the use of acid that becomes a well stimulation treatment. And so, how does one distinguish between the two? Hasn't the State Department of Gas and Geothermal Resources already covered that subject?
Yes, they make the distinction clear. They have permits that one must apply for that specify the intention with that permit. And that intention will either state this is an intent to rework a well for drilling, or is an intent to have a new well stimulation treatment. It's hard to show an example of that permit since it does not currently occur here.
But hasn't DOGGR, the Department of Gas and Geothermal Resources, set thresholds, established thresholds, below which the use of acid is deemed to be well maintenance, and above which it is deemed to be a well stimulation treatment? And if you don't know, it's okay to say that. I'm just asking you if you're aware of whether that is the case.
I do not know where DOGGR draws that line. All I know is what Measure Z prohibits.
All right. So, are you aware whether DOGGR has drawn that line?
Distinguishing between well stimulation treatment and maintenance.
Yes, with respect to the use of acid, recognizing that some is used in well maintenance.
I do not know for certain. No.
All right. So, where would one go to make that determination?
One does not need to look for that determination within the text of Measure Z. One can look to the permits that are already being applied for at the state level, and then following that permit, you must additionally get permission at the county level. And that is when the county, not requiring any technical expertise, but simply seeing what type of permit is being applied for, has the ability to prohibit specific land uses.
Doesn't it become iterative at that point? If the Department of Gas and Geothermal Resources is already making that assessment and granting those permits?
No. Currently, there are already county permits that all oil production must obtain before they can continue with drilling operations. This is simply continuing that, just like any development project may need state level permits, then also must seek permission to continue with that project at the county level. Now, moving to wastewater injection. Yesterday, we discussed why wastewater injection prohibitions are not preempted at the federal level due to the express non-preemption clause. However, you raised a question as to the state regulations that surround wastewater injection.
I have some more questions actually about that, because I'm not sure I entirely understand your position. Doesn't the savings clause subsection D you were talking yesterday about setting a minimum standard or a minimum
Yes.
floor for state regulations. But does it, the caveat that says the state regulations may not impair or impede with a cap on the extent to which a state may regulate underground injection?
The cap, as you phrase it, that sub-provision sets is simply on how high the minimum floor at the federal level can go. That is not a cap on states and localities going further.
So are you saying that the state cannot impair or impede underground injection, but a local municipality can?
I am saying that the state's federally approved underground injection control program through the Safe Drinking Water Act may not go beyond that minimum floor. However, the state may build upon that as well as localities.
Well, what's a minimum floor? That's the problem I'm having understood, because it says it cannot impair or impede, it cannot enact regulations which impair or impede underground injection. And that doesn't sound like a floor, it sounds like a ceiling to me. But I invite you to comment.
Yes, happy to. That sub-provision really distracts from the entire purpose of the Act. If you look to 10th Circuit cases that describe the purpose, we can go back a couple slides, please. You can look at Ardo Oil and Gas Company, where they say, to the extent that the House report reflects a concern about excessive regulation of the oil and gas industry in general, which is what that subprovision you were mentioning does, it expressly subjects this concern to the overriding goal of protecting the quality of drinking water. Those are the minimum floors. These are protections on drinking water, and that is a minimum floor which should not be gone below. In setting that minimum floor, one must still consider, and the federal government did not want to include any brine injection at the federal government level through this program. However, since these are just minimum floors, they would allow states and localities to further protect that drinking water, as is the overriding purpose.
Wouldn't it be a little strange to say the federal government has decreed that states cannot impair or impede injection, but local municipalities can?
No, Your Honor, because what they are saying is that the program they will force upon states cannot force them to have a minimum floor that is that high. Because if states do not take primacy over this program, then the federal government will run an underground injection control program. And in that situation, when states do not want to set higher floors, the federal government is saying, Congress is saying, we will limit how high these minimum floors can be.
What would the point of that be? Local municipalities could then come in and outlaw what the federal legislation says. The states who are administering these programs under the Safe Drinking Water Act cannot.
The state is also allowed to prohibit it. The prohibition can occur at either the state or local level. What that sub-provision at addressing the limitations for that floor for underground injection of brine, that is not a requirement that one mandate underground injection of water. That is simply saying if a state chooses to allow it, then they can do so so long as they meet the minimum floor requirements laid out in the Safe Drinking Water Act.
which include not comparing or impeding underground injection.
That is the minimum floor that they are constrained by, yes.
Yesterday, you referred to when you were comparing the savings clauses between oil and gas and timber, referring to Big Creek.
Yes.
Can you access that slide?
Yes, sir.
Raise that.
It goes a bit further along. I was trying to address your question, so we slightly changed the order of our slides, but I believe we have the comparison and contrasting slide, correct?
Yeah, you had, I think you had the safety classes side by side.
Yes. But yes, the Big Creek Lumber one, which preempted conduct, whereas the other savings clause allowed location and conduct. Here it is. This is at the state level, let me clarify, but happy to discuss it in this context.
But there was a savings clause. This is more an empowerment.
Oh, yes.
I think you cited Public Resources Code Section 3190, if that helps.
Yeah, the
Support staff.
3690.
Okay. So if that's there, then you can find it great. If not, don't worry.
Here it is. They found it. Sorry for that.
3690.
Yes.
All right. Well, I need a few more books. You did have 36. Is 3690 the one that only applies to a chapter?
It applies to unitized operations, yes.
Then, what bearing does that have?
It actually does have good bearing because the history of Section 3690, it was first implemented in 1971 when California began unitizing operations. And with that context, the reason they began unitizing operations was to increase the efficiency of oil production. So with unitized operations, the express goal or purpose was more efficient oil production. Yet even in that section, where the goal and purpose is more efficient production, they have an express non-preemption clause. However, what that is simply codifying is what was already relevant in law, called the case law prior to unitization, that found that prohibitions against oil and gas regulations were not preempted.
Can that also be read as conferring it because somebody thought unless they conferred it would be deemed preempted?
Yes, within that new chapter that came in 1971 to which it applies to unitized operations.
But by its terms, it's confined to that particular chapter which deals with unitizing.
Yes, as it is worth noting that San Ardo is a unitized operation, as are the majority of operations in California. And it does explicitly apply to that, but it simply codifies what case law had already upheld, as well as the lack of legislation that would expressly preempt oil and gas regulation at the county level, as we see express preemption in timber operations in Big Creek. Okay. So, back to wastewater injection specifically. Do you have any further questions on why at the federal level there was the express non-preemption clause? And that is what the sub-provision related to state underground injection control provisions is subordinate to?
Are you talking about the last subsection?
Yes.
42 U.S. Code?
Yes, 42 U.S. 300 H2D. And the language of that states that nothing in this subchapter, and subchapter applies to the entire Safe Drinking Water Act, shall diminish any authority of a state or political subdivision to to adopt or enforce any law or regulation respecting underground injection.
And what's the part that you stopped and didn't include, say?
Let me see where the remainder of that language is.
Does it say, but no such law or regulation shall relieve any person of any requirement otherwise applicable under this subchapter,
Yes, I believe that is the language.
which would include the requirement under section 2 that state underground injection control programs may not interfere or impede with underground injection, right?
Yes, that is a restriction on the federally approved underground injection control programs. As you said at the very start of that reading for that sub-provision, is explicitly limiting what those underground injection control programs must consider before finding endangerment and prohibiting underground injection. But that does not control localities and states beyond that. As we see in New York State, where they chose not to take primacy. This is a situation in which the federal government is enforcing the Safe Drinking Water Act and following the minimum floor restrictions, as you discussed, about not prohibiting underground injection unless they find endangerment. However, the state of New York was allowed to further build upon that and have additional regulations and monitoring requirements that were found not preempted.
Does it allow the outright ban?
It is not an outright ban.
What is not?
The New York regulations that were found not preempted.
Measure C.
Measure Z does explicitly prohibit wastewater injection for storage and disposal.
And is it your position that 300H-2D allows an outright ban of underground injection?
Yes, it does, because that applies to the entire act, whereas limitations within that sub-provision are really siloed into a smaller subsection that only apply to the regulations for state programs, as that section of that act is titled, in which that limitation is found. And that is why the express non-preemption clause does overrule that, and it is subordinate to it. Further, you also asked about the state regulations related to wastewater injection. But before we get to the specific ones that get at wastewater injection, I would first like to address the few regulations that plaintiffs raise that they claim are kind of overarching in dictating what is preempted at the state level. All they have are section 3400 and section 3106. But neither of these meet the burden to overcome the presumption against preemption. Again, we must place these in context. Section 3400 is actually within a fiscal section, getting at the financing for, as you can see on this slide, it gets at the assessment and collection of charges. What plaintiffs cite in their slide from yesterday, slide 21, I believe, is that the people of the state have a primary and supreme interest in the deposits of oil and gas within the state, which are supervised and protected by the state. What section 3400 actually says is, the charges directed to be levied by this article are necessary in the exercise of the police power of the state and to provide a means by which to supervise and protect deposits of oil and gas within the state, in which deposits the people of the state have a primary and supreme interest. All this section is getting at is justifying placing a charge and a fee to have oil production so that the program at the state level, which has regulations, may fund itself. It's really just a funding mechanism. For that reason, section 3400 does not really address the issue of preemption because it is not claiming any part of the field that local counties are prohibited from regulating. Additionally, plaintiffs also heavily rely on section 3106. And section 3106 is within the administrative section. As you can see here, it's in the section that lays out essentially what different groups should do, should supervise, what they're authorized to then later enact regulations related to. Again, Chevron cites on slide 19, DOGGR shall permit the owners or operators of the wells to utilize all methods and practices known to the oil industry for the purpose of increasing the ultimate recovery of underground hydrocarbons. But that ellipses is really key in understanding what section 3106B actually says. Within that ellipses, it states, the supervisor shall also supervise the drilling, operation, maintenance, and abandonment of wells so as to permit all methods, or to permit operators to utilize methods for oil production. And really what this is getting at is that it's a supervisory role, and it's laying out the framework in this authorization regulation really to allow DOGGR to then supervise these things, but it is not mandating. The shall permit is almost misleading in saying you must permit operations. In fact, if we go to the next slide, subprovision A, which comes before this, outlines, I would say, the first thing that the supervisor should consider. And the supervisor shall so supervise the drilling so as to prevent, as far as possible, damage to life, health, property, and natural resources.
And what significance is that?
The significance is that section 3106 is not the same as a preemption clause. It is rather just laying out an authorization for DOGGR supervisor to supervise oil production. It's not saying that one must permit, and thus it is not creating a conflict with local prohibitions because permitting is not mandatory. It is simply their encouragement that they would supervise operations so that oil, when it is developed, is done so prudently and reasonably. It is not mandating that all oil be drawn out.
So does the legislature say that the Department of Gas and Geothermal Resources shall supervise it so as to permit the extraction of oil and gas, but local municipalities can outlaw it?
Based on case law that has upheld total prohibitions of oil and gas operations within cities and counties, yes, that is exactly what that is saying. It is simply saying that when oil operations occur, you should supervise them. This is to the supervisor of DOGGR, so that operations for a lessee are done as how a prudent operator would do them, are done reasonably. It encourages the wise development of oil and gas resources when they do occur. And I would just like to contrast that with other cases and other regulatory schemes within the state of California that have found regulatory language that is preemptive, just to emphasize how much section 3106 is not in fact preempting any prohibition at the local level. The first example we discussed yesterday, which is Big Creek Lumber, where in California Public Resources Code, section 4515.5D, it expressly says, except as provided in subdivision E, individual counties shall not otherwise regulate the conduct of timber operations as defined in this chapter, or require the issuance of any permit or license for those operations. And again, I will reiterate that that express preemption was even read narrowly to only preempt the conduct, the regulation of conduct for timber operations, and the court found that localities could still regulate the location and whether timber operations would occur. It was simply read to preempt regulation over conduct. The next example we have, on the next slide, is an example in fiscal, which is also cited by plaintiffs and was concerned with gun regulation. And they found that there was field preemption when, in the California Government Code, section 53071, it clearly states, it is the intention of the legislature to occupy the whole field of regulation of the registration or licensing of commercially manufactured firearms as encompassed by the provisions of the Penal Code, and such provisions shall be exclusive of all local regulations relating to the registration or licensing of commercially manufactured firearms by any political subdivision. Such strong regulatory language is not present here. It is not present in section 3106, and as I said before, in the unitized section, such express non-preemption language is actually what we find. One more example for you is also in fiscal, when determining whether or not there's conflict preemption at the state level. They reference California Penal Code, section 25605, which states, no permit or license to purchase, own, possess, keep, or carry, either openly or concealed, shall be required of any citizen of the United States or legal resident over the age of 18 years who resides or is temporarily within this state and who is not within the accepted classes. This was in response to an attempt by the city of San Francisco to prohibit having any guns within the city. And they found these two regulations, one within the California Government Code and one within the Penal Code, to clearly preempt and to meet that burden that one must when there is a presumption against preemption, as is discussed in Big Creek Lumber. And then one more section I'd like to compare for you, because you mentioned it yesterday, and that was section 3700, related to geothermal resources. And as I said before, this is in geothermal resources, but perhaps illustrates if legislature had intended to try and occupy the field, what an express policy would look like. Within section 3700, it says, "It is hereby found and determined that the people of the state of California have a direct and primary interest in the development of geothermal resources, and that the state of California, through the authority vested in the state oil and gas supervisor, should exercise its power and jurisdiction to require that wells for the discovery and production of geothermal resources be drilled, operated, maintained, and abandoned in such manner as to safeguard life, health, property, and the public welfare, and to encourage maximum economic recovery." The next slide contrasts this with what section 3106B states. And really, section 3106B also has that supervisory language, but it lacks the finding that there is a direct and primary interest in the development of geothermal resources in the context of oil and gas regulation. And it is this absence that further underlines why section 3106B should not be found to be preemptive language.
But haven't you only accepted part of the language of 3106B, where it goes on to say that it is hereby declared as a policy of this state that the grant of an oil and gas lease or contract to a lessee or operator of the right or power and substance to explore for or remove all hydrocarbons from any lands in the state, in the absence of an express permission of the contract contained in the lease or contract, is deemed to allow the lessee or contract to do a proven operator using reasonable diligence.
Yes, we did not include that, but I'm happy to discuss it because the policy of the state, if you get rid of a lot of the language in the middle, just to shorten really what they're saying. So the policy of the state is that the grant in an oil and gas lease or contract to a lessee or operator of the right to explore for oil is deemed to allow the lessee or contractor to do what a prudent operator using reasonable diligence would do. And essentially what that is saying is that it is the state's policy that when one does get a permit to do oil operations, the state will encourage it be done prudently and with reasonable diligence. And that is perfectly fine, and Measure Z encourages prudent and reasonably diligent oil production when it occurs. Measure Z does not conflict with that, rather it is prohibiting new wells and well stimulation treatment and wastewater injection in Monterey County. But with the wells that remain, Measure Z does not conflict at all with their prudent operation. So it is for that reason that Section 3106 is really not relevant to the inquiry of whether or not wastewater injection is preempted by state law. Instead, I look to address the state regulations that are specific to wastewater injection. And there are really only two sections. There's the California Public Resources Code, Section 3130 to 3132. I think I misstated the number yesterday, so I apologize. But within those sections, will you go up one more slide? Back to 21. Great. It's really simply capturing the Safe Drinking Water Act provisions within the California Public Resources Code. Section 3130 defines terms used in the underground injection control program. And then Section 3131 actually addresses that express non-preemption clause that we see in the Safe Drinking Water Act, because it's requiring consultation with state regional water quality control boards before sending off an aquifer exemption onto the EPA. And that shows how the state has the ability to consult and set further requirements through its regional water quality control boards before determining that that operation is permissible. It's building upon those minimum floors, as is a reserved right by the Safe Drinking Water Act. And then finally, Section 3132 simply requires notifying the relevant policy committees before submitting that exemption proposal to the EPA. So none of these three sections within the California Public Resources Code has any preemptive language or preemptive intent that would stop localities from further regulating or prohibiting wastewater injection. The second part is on the next slide, 14 Cal Code Regs 1724.6, 1724.9, and 1724.10. And these are really fairly simple. The first one just requires that the division approve subsurface injection before beginning. So one must get a state permit, just as one must also get county level permits for developments and operations. Section 1724.9 requires that the operator state how it will dispose of wastewater. So it must simply clarify what method it will use, because wastewater injection is not the sole method possible for wastewater disposal. And then Section 1724.10 has the technical and reporting requirements. And I will discuss later why these technical requirements are really quite narrow and discrete, and Measure Z does not try to interfere at all with technical requirements related to pipe size, related to the mixture of cement that must be used. These technicalities are not at all what Measure Z attempts to regulate. And so it's for these reasons that an underground injection or a prohibition against wastewater injection is not preempted by any of these state regulations. In fact, even DOGGR said in a letter that it sent clarifying that the underground injection control program does not preempt. I will read that quote to you now. This is from earlier this year, February, and it is in our record for judicial notice, Exhibit L. Neither the approval of an aquifer exemption nor the divisions, referencing DOGGR here, issuance of permits will excuse operators from complying with Measure Z or otherwise undermine in any way Monterey County's enforcement of Measure Z. In fact, the division's permits state that operators must comply with other federal, state, and local laws. This is reiterating what was already clear in the express non-preemption clause for state underground injection control programs as seen in the Safe Drinking Water Act. And it is for these reasons that Measure Z's prohibition against wastewater injection falls perfectly in line with their retained local police powers. And now I will move on to the prohibition against new wells. And again, plaintiffs fail to meet the burden against the presumption against preemption. The authorities they cite are not in fact preempted. We've already covered Section 3400 and Section 3106. But the other things plaintiffs draw upon include the Attorney General's opinion, which really sets an artificial distinction, as well as the state's environmental impact report. Instead, we have an express non-preemption clause, as we discussed, Section 3690, again listed here for you. And as I explained, this applies to unitized operations, such as San Ardo, but really codifies the idea that police powers retained, which over a century of case law had already found to be true. And rather than overturning that, the legislature reaffirmed that by having such explicit legislation. The cases listed here are directly on point. They uphold police power by doing preemption analysis, not using the word preemption, because it was so clear that this field was left open to oil and gas regulation. Instead, you look at cases such as Beverly Oil, as I discussed yesterday, that have prohibitions on new wells, as well as a prohibition on deeper well construction. Can you go to the next slide? Thank you. Prohibiting deepening of wells for increased production. And the court upheld this prohibition, and they even considered Section 3400. And just as it is not relevant today, the court found it was not relevant then. In fact, they go even further to say, had there been a strong policy, that would not be sufficient to prohibit or to preempt local cities and counties from having such prohibitions. The quote,
In the limits of Beverly Hills.
this was in the city of Los Angeles, actually. It's Beverly Oil, but it is the city of Los Angeles that has the prohibition. And it says, the people have a primary and supreme interest in oil deposits. And that's quoting California Public Resources Code, Section 3400. And it is recognized that oil production is a business which must operate, if at all, where the resources are found. Nevertheless, city zoning ordinances prohibiting the production of oil in designated areas have been held valid.
All right, and that raises the question, what's the difference between prohibiting it in a designated area and flat outright banning it anywhere within the county?
Both prohibitions are valid at the local level because it gets to location. You look at far more recent cases, such as Hermosa Beach, which does an entire region-wide prohibition on all oil production activities, and that was upheld. And this is in 2001, after far more legislation has been passed, after the unitization provision came out in the 1970s, after the amendments to Section 3106B, which were mentioned by plaintiffs yesterday, after those had come through. And still, an entire prohibition against the entire area was held to be valid. The requirement in all of these is simply that it be reasonable as to why one is prohibiting in that location.
Well, is there a difference between prohibiting oil drilling on Main Street and prohibiting it in an area, a sparsely populated area where drilling has gone on for decades?
No, because if the things that the county is seeking to protect in their prohibition, such as the safety of drinking water, such as reducing emissions and preventing spills, that is relevant county-wide. Underground water flows far beyond any contained area, and all of the water within Monterey County is very vital to the county. And I don't want to get into the facts and technicalities because I think that gets to more the kind of as applied specific to this case instance. However, it should be considered that within oil regulation for a county, when water is threatened, that considers the entire area. It is not cabined to a downtown versus a more rural area. The reasonableness here is met because the county's Measure Z does have reasons that would justify an entire prohibition. Additionally, this case law, such as Beverly Oil, shows that there's a long history of not preempting local prohibitions. And the only thing that plaintiffs can bring is no case law finding this to be the point, but rather the Attorney General's opinion, which actually does not agree with them. The Attorney General's opinion says that local counties are not preempted. Rather, it says in the very summary, page 461 as cited, is the very top summary at the start of the Attorney General's opinion. And it says, with regard to state regulation for other purposes, such as land use control and environmental protection, the state has not fully occupied the field, and more stringent supplemental regulation by cities and counties is valid to the extent that it does not conflict or interfere with state regulation.
Doesn't it go on to say that subsurface underground activities are regulated by the state, and if you're above ground, then it's the province and local government?
There is one section actually immediately before this quote that does say there is a discrete field of technical regulations which is likely preempted. And Measure Z does not attempt to get into these technical regulations.
So it doesn't say make a distinction based on whether it's below ground or above ground?
When narrowing the field of technical regulations, the Attorney General's opinion narrows that to downhole technical regulations. And let me take this moment to make clear that interveners do not agree with this artificial distinction between surface and downhole operations. Because as we've been dancing around yesterday and now today, there really is no clear distinction. Any well activity below ground is accompanied inherently by surface activities, trucks coming onto the site, forming new well pads, clearing vegetation, having blenders on the surface, having mixers, bringing in generators. All these surface activities occur with any underground activity. The distinction that the Attorney General's opinion makes is that the only thing that is shown to be preempted in its analysis are some technical downhole things. But that is not saying that there's an entire downhole world in which states cannot regulate. In fact, you go all the way back to Beverly Oil, which the Attorney General's opinion cites to, and within Beverly Oil, they had a prohibition against deepening of wells. Deepening wells clearly gets at activity that is below ground, and yet the Attorney General's opinion works with that case and says things like that are not preempted. They're only technical requirements. As you see in the limited field rules and the limited permitting scheme from DOGGR, that says things like one must have 6-inch wide piping or must have 35% silica flour. I show you here an illustration of the one page of field rules, which actually is Exhibit 25 in Chevron's RJN. These field rules are not expansive and do not occupy this entire field. These technical requirements are actually quite limited. We look again to a permit that plaintiff showed you yesterday with 11 provisions that must be met. These include things like, I said before, the percentage of silica flour, 7-inch casings, and a minimum 6-inch diverter vent line. These are those technical situations that Measure Z does not wish to regulate at all. Rather, Measure Z wishes to prohibit a land use. And the prohibition against new wells and the prohibition against well stimulation treatment falls within those land uses. And it is not at all trying to conflict that when these oil operations occur, that those are the standards and the technicalities that must be met under DOGGR's regulations. And so that is why the Attorney General's opinion actually supports Measure Z by having language that finds cities and counties are not preempted from prohibiting oil and gas regulations.
Is there a phrase in the Attorney General's opinion that says that there is very little room for local regulation?
I do not have that exact line, but I believe it does when referring to the technical requirements. Would you like me to pull up that language for you?
No, just that, well, go ahead.
Yeah.
But assuming it's there, I would like you to comment.
Okay, yes, well, we'll assume it's there because where I recall that provision you mentioned, that is in reference to the downhole technical requirements that are already laid out at the state level. And as I've shown you, those are very technical requirements as to pipe length, as to the type of concrete that one uses. But that opinion was written when things such as Beverly Oil, prohibiting deepening of wells, was upheld as a valid prohibition. And further, the Attorney General's opinion doesn't change the law. After that interpretation, the legislature had multiple opportunities to further clarify and make express preemption or make clear their intent to build upon what the Attorney General found to be really a narrow field that was preempted to solely these technical requirements, and the legislature failed to do so. In fact, we see quite the opposite in silence in response to prohibitions like Hermosa Beach that outright prohibit oil and gas regulations entirely.
Are you saying you agree with, or do not agree with, or agree with part and disagree with another part of the Attorney General's opinion?
We disagree with plaintiff's interpretation of the Attorney General opinion. We agree with the Attorney General opinion finding that local prohibitions are not preempted, and we are willing to concede that there may be a possibility that technical requirements, if a locality were to try and interfere with those technical requirements laid at the state level, that one could find those are preempted. But that is not what's at issue with Measure Z. That is not what's at issue now. Really, the Attorney General's opinion does not impact or change how one should read Measure Z. If anything, it simply affirms that Measure Z is well within its local police power. So, for that reason, it's well settled that Measure Z's prohibition on new wells is not preempted based on this case law going back to 1925. The Attorney General's opinion does not change that law and rather reflects that. It's for that reason, moving to the prohibition on well stimulation treatment, that one can find the same. When you move past this artificial distinction that plaintiffs try to create using the Attorney General's opinion, which is not actually reflected in any case law or in any regulations, I will emphasize that not a single California Code of Regulations uses that term downhole especially not in accompanying with any preemptive language, as we see preemptive intent in other regulations in the timber industry or in gun control. Rather, the Attorney General's opinion simply shows us what case law shows us, and that is that localities retain that police power to preempt uses of land. And inherently, well stimulation treatment has surface and downhole or subsurface components. That does not mean that localities are preempted from prohibiting that. We can look to, again, as I don't want to be redundant, so I will just say, if you look to SB4 now, which is actually directly related to well stimulation treatment, we're getting this artificial distinction in the Attorney General's opinion. SB4 has an express non-preemption clause that says this article does not relieve the division, referring to DOGGR, or any other agency from complying with any other provision of existing laws, regulations, and orders.
What's the significance of the word existing?
The significance of the word existing is what laws are currently in existence. I would argue that because Measure Z exists, that they must comply with that. But even if you were...
Now that did not then.
No, it did not exist then. However, if you look to what the author of that very piece of legislation said when saying how one should interpret this, she goes...
Are you referring to Senator Pavley's letter?
Yes.
What is, let's talk about the admissibility. What is the theory on which that letter is admissible?
My co-counsel addresses it in our response to evidentiary objections, but I will do my best to summarize that here.
That's okay. I can look.
You can look at them.
Okay.
Okay. But,
But I do have real reservations about
okay.
it.
Well, I believe that SB4, regardless of what this letter says, does not preempt a prohibition on well stimulation treatment. Rather, it is getting to the technical requirements of how well stimulation treatment should occur if it is to occur. What Measure Z is addressing does not try to get into those technical requirements related to well stimulation treatment. Rather, it says we are prohibiting that practice entirely within this location. As we've said before, Section 3690 of the California Public Resources Code reserves the right of localities to set regulations as to the conduct and location. But Measure Z does not even go that far. It simply seeks to regulate the location of well stimulation treatment, and it prohibits any well stimulation treatment from occurring within Monterey County. This is not preempted by SB4. It is not preempted by anything the plaintiffs raised today. Rather, it is simply reaffirming what has long been the retained local police power. And this is because well stimulation treatment has many impacts, surface, downhole, at all levels that would occur throughout the county. And if one were to read how plaintiffs are framing this argument, it comes to almost a ridiculous conclusion that a county could never restrict or regulate any oil and gas in any manner, which is not currently the case in the state of California, and no case law or regulations suggest otherwise. In fact, these all reaffirm that counties and cities have the ability to prohibit oil and gas operations. They make no distinction between surface and downhole, rather simply a land use. And SB4 does not say that one must permit fracking to occur in one's county. It simply gives you technical requirements that must be met if you choose to have well stimulation treatment occur within your county. And Measure Z is prohibiting the location of that use within its county. And so, in conclusion, plaintiffs have not met their burden to meet this presumption against preemption. They reference irrelevant regulations, such as Section 3106 and 3400, and they really only have the Attorney General's opinion to rely upon. But that is misframing it to set this artificial distinction, when really that opinion reaffirms localities' right and power to prohibit oil and gas and to regulate oil and gas. And aside from that, I think they merely reference environmental impact reports. Those do not have the power to change the law. And so it would be a shocking departure from case precedent, from how California Supreme Court has before interpreted prohibitions against oil and gas regulation define that Measure Z is preempted. Measure Z's 3 prohibitions fall well within the local land use authority. Thank you. And now my co-counsel will discuss severability.
Right, Mr. Ardo.
Good afternoon, Your Honor. Peter Orradre for interveners. I'd like to discuss severability quickly. But before I do that, I just want to circle back and touch on a question that Your Honor had earlier for my co-counsel. And that was on the issue of distinguishing between well maintenance using acid and well stimulation treatments, and whether or not DOGGR had promulgated a standard by which we evaluate what constitutes maintenance on the one hand and what constitutes well stimulation treatment on the other hand. And the clear answer is yes, DOGGR has done that, which makes it easy for the county then to distinguish what constitutes, under Measure Z, a well stimulation treatment, which is prohibited, and simple maintenance, which is not prohibited. And I think that is important, not just in that specific instance, but because it gets to a larger question, which I haven't heard the county address head-on quite yet, which is that Measure Z is a land use policy, 3 policies actually, inserted into a general plan. And a general plan is a constitution for development in a county. Land use policies are a starting point, and as with other zoning policies, they don't need to emerge 100% formed and complete such that they can be clearly applied in every conceivable instance. That's what implementing ordinances are for. And that's why when a general plan policy prohibits, say, industrial uses in certain zones in the county, it's unclear on the face, potentially, what an industrial use is, and the county can then adopt implementing ordinances to clarify more specifically how it's going to enforce that particular policy. So what we've got here are land use policies, and what the county is going to do is, as it does with every other general plan land use policy, adopt implementing ordinances to effectuate those policies. So, and I'll just add that the county has considerable interpretive leeway in doing so, and specifically in the county's brief on general plan consistency, it cites several cases describing the counties, the deference that courts give to counties when they do in fact interpret general plan policies and implement them. So I'd like to turn to severability and start by simply setting the record straight on the applicable test. I think I heard plaintiffs' counsel yesterday say that proponents must put on competent evidence that Measure Z can be severed. And I think that, frankly, that's wrong. There is no evidentiary burden on plaintiffs. As I'll explain in a little more detail, the court need not, and in fact may not, look beyond the face of the initiative itself and the accompanying official ballot materials in order to determine whether or not the initiative is severable. And
What authority do you have for that proposition?
Sure. I'll have to skip around a little bit in order to do that.
But as long as you get to it, it's up.
We'll get to that. We'll certainly don't. And second is, I think that mischaracterizes the burden of proof, which is that the presumption of severability lies in favor of severing an initiative. And that's made clear in the case Durkin versus Fair Political Practices Commission, which the plaintiffs cited yesterday. And this is really the lodestone California Supreme Court case setting forth the standard for severability for an initiative. I'd like to from Justice Baxter's concurring opinion, in which he describes, he agrees with the majority opinion here. He says, in considering the issue of severability, it must be recognized that the general presumption of constitutionality. So again, this operates on top of a general presumption of constitutionality, fortified by the express statement of a severability clause, normally calls for sustaining any valid portion of a statute unconstitutional in part. An express statement of severability generally imposes on the courts the duty of sustaining the electorate's will as far as possible. So courts will bend over backwards to find that initiatives are severable where possible. And the cases bear that out, including the cases cited by Aera yesterday. I think they cited another case, MTP, which we'll get to here, I'll cite to it. But that case also found, like Gherkin, that an initiative measure, in that case a rent control ordinance, was severable. And Gherkin involved a proposition that contained a wide variety of criminal justice measures and a ballot proposition. And again, the Supreme Court found that initiative to be severable. And so when we're looking at voter intent, I think the first place we need to go is the text of the measure itself. And Measure Z, as the county indicated, contains an extensive severability clause. It states, if any portion of this initiative is held to be invalid or unconstitutional by a final judgment of a court of competent jurisdiction, such decision shall not affect the validity of the remaining portion of this initiative. That's nearly the exact language the court was considering in Gherkin. Measure Z's severability clause goes further than the Gherkin severability clause. And it says the voters hereby declare that this initiative and each portion thereof would have been adopted or passed, even if one or more portions were declared invalid or unconstitutional. So this is a clear statement of voter intent here. It's not a one-liner saying Measure Z is severable. A clear statement of voter intent. So the Gherkin court identified three aspects of severability, and I heard Your Honor recite them probably in the first 5 minutes of the proceedings yesterday. So I won't belabor them, but again, they're volitional severability, grammatical severability, and functional severability. And in considering that first aspect, volitional severability, the Gherkin court found that if it is reasonable to assume that the portion of the initiative to be severed reflects a substantial portion of the electorate's purpose, that part can and should be severed and given operative effect. Again, Measure Z contains 3 separate land use policies, and each of those policies work toward environmentally protected goals. And if you look at the initiative itself, on page AR 121, that's the first page of Measure Z. Both the purpose and effect, and I don't have a slide up here, Your Honor, I apologize for that, on that, for that first page. But if you look at that first page in the record, the first page, under both the purpose and effect sections, which are the first 2 full subsections of the initiative, the first 2 full paragraphs, both of those sections describe each of Measure Z's 3 policies in full detail. So on the face of the measure, voters were apprised of each of those 3 policies. And the findings additionally discuss variously impacts deriving from, respectively, well stimulation treatments, drilling new wells, and wastewater injection and impoundment. So furthermore, looking beyond just the measure itself and sort of peering into the ballot materials now, we see here the ballot question. And it actually came to our and the county's attention that the administrative record version of the ballot question was unsigned by the county, the resolution. So the county's prepared to submit a signed, certified copy of that. So we'll take care of that. But the ballot question here is what voters looked at when they sat down to vote for Measure Z. And I think we have a lot of perhaps people in this room who confronted this very question. And it says, shall an initiative amending the Monterey County General Plan, Local Coastal Program, and Fort Ord Master Plan to 1. Prohibit the use of land within the county's unincorporated, non-city areas for hydraulic fracturing treatments, fracking, acid well stimulation treatments, and other well stimulation treatments, semicolon, 2. Prohibit new and phase out existing land uses that utilize oil and gas wastewater injection and impoundment, semicolon, and 3. Prohibit the drilling of new oil and gas wells in the county's unincorporated areas be adopted, yes or no. So a voter literally could not vote on this measure without being confronted by language disclosing all three aspects, all three land use policies. Now, you asked earlier, Your Honor, for authority on this question of considering text and ballot materials. And again, I was relying a lot on the Gerken case. It's an important case here on severability. The court said we must look to the initiative measures text and the ballot materials for guidance. It later said it arrived at its conclusion that the provisions of Proposition 8 were severable based on its view of the ballot materials as a whole. And that's at page 719. Another case following Gerken and explaining what courts consider when they consider this issue of severability is California Gill Netters Association, where the court said we may examine the proposition itself, that is the text of the initiative, as well as the ballot materials to evaluate this issue. Now, plaintiffs brought to your attention yesterday 2 cases in which they suggest stand for the proposition that courts can consider the various materials that they put before the court.
I'm not convinced of those cases. Why? Those are some subject cases. They don't have to be severability issue. My question to you is there any authority that says one can only look at the initiative measures text and ballot materials for guidance? Because one of the things you're looking at under volitional severability is whether the voters would have enacted a portion independently of the others. And so far, I don't think anybody's cited any authority that says that inquiry is confined to looking at the text of the measure and the ballot materials. But if the evidence goes, such relevant evidence is admissible. And except as otherwise provided by statute, all relevant evidence is admissible. Evidence code section 2. It's 351. Evidence generally is relevant if it tends in logic or in reason to prove some fact. At some point, you have to limit what types of materials come in, because there has to be some in. Does the statements made by the proponents of it because they tend to show what was presented to the voters.
No, they don't.
Why not?
As Your Honor noted, there needs to be a limit. Because on the one hand, you have the ballot question, which was clearly before the voters. But on the other hand, at the extreme, you have statements of individual voters who are opposed to the measure speaking off the cuff, which plaintiffs have cited in their briefs. You have lawn signs, and you have any number of statements that arise in the flurry of a political campaign that are made by proponents, opponents, so-called opponents, and
Presented to the public at large. Obviously, including, maybe not so obviously, but including single statements made by a proponent of the measure to a member of the Board of Supervisors would not tend to show in logic and reason what was presented to the voters. So that's the area I'm concerned. Mass circulation of posters by the proponents was shown to be for the proponents. Are those relevant and are they necessary? They're not. When?
No, Your Honor, they're not relevant and they're not admissible. And I think the key here is your description of given out to the public at large. What the courts are intensely concerned with when they're considering initiative measures is the will of the voters. Not the will of the people, but it's a question of legislative intent. And the legislators, in this case, are the voters. And so the question is, what were the voters thinking when they voted for Measure Z? Now, if you have a statement made before the board, maybe you have 50 people or 100 people in that room that heard that statement. And maybe all of them are voters, but that represents a very small subset of voters who actually went to the ballot and voted. But if you have a statement made in the official ballot materials, which are distributed to each voter, and which are presumed by courts, and I don't have the slide up here because it's these statements are in single subject rule cases, but I can get those to you, which are presumed, thank you, which are presumed by courts to be considered by voters. That's how we know, and that's how courts have decided what voters are thinking, what they're considering, is by looking at the ballot materials. And that line, that bright line, stops exactly at where the statements are no longer in official ballot materials. And that's why the courts stop there. And although you're right, Gherkin and California Guildmetters Association do not expressly say, we will not consider materials falling outside of this line. It's implicit when they say, here's what we are considering, and we're stopping at the official ballot materials, that that's what they're doing. And that's the reason they're doing it.
Is there any indication anything beyond the ballot materials and measure of intent was presented to the court? I don't think there was.
I'm sorry, can you repeat the question?
Sure. Is there any indication that something beyond the measure text and the ballot materials in Gherkin were presented to the court to consider in trying to determine volitional severability?
I don't believe so. No, Your Honor. But again, when you ask, what the authority, let's couch it differently. What's the authority for the proposition that courts can actually wade into the thicket of campaign materials?
As opposed to Evidence Code Section 351 that says all relevant evidence is admissible except as otherwise provided by statute.
Well, evidence may be admissible under the evidence code. That doesn't necessarily mean that it falls within the legal framework of what courts will actually consider pursuant to the long line of case law in the initiative context when addressing the questions of severability can single subject rule. So maybe there's some space there, maybe the evidence is admissible, but again, the court would be on in unprecedented territory, frankly, if it extended the reach of its consideration into the back and forth of a political campaign and statements made during that campaign, retroactively pulling those statements out.
Let's talk about campaign signs. Let's limit it to that. Mass circulation of campaign signs that say specifically, Measure Z ban fracking. They don't say ban fracking and well stimulation treatments. They don't say ban fracking and new wells. It says ban fracking. Are those admissible if shown to be circulated en masse by proponents of the measure?
Admissible for what purpose, Your Honor?
On the issue of volitional severability.
No, they are not.
All right, so the court could not consider those in determining whether, if, for instance, it were to find that the well stimulation treatments and the new well drilling prohibitions were preempted. The court could not consider those signs in determining whether the fracking portion should remain.
No, Your Honor. My position is that the court is confined to the ballot materials on that issue, and on interpretive issues with respect to initiatives generally.
Okay.
And the court would be well positioned to base its ruling exclusively on the ballot materials and the base of the initiative. And again, on shaky ground, if it reached into the world campaign
So
stage.
tell me why shaky. As we come back to what I asked you initially, is there anything that limits what the court can consider? Or anything that says the court cannot consider anything beyond the text of the measure of the ballot materials in determining volitional severability?
Expressly, no, Your Honor. If you're looking for a provision in the Elections Code or something more than the cases I've cited here, obviously I've given you what I've got here. But I think that when the Gherkin Court says viewing the ballot materials as a whole, or when the California Bill Letters Association Court says we may examine the proposition itself as well as the ballot materials, and the Elections Code itself identifies ballot materials in California Elections Code Section 9162, I believe that's a clear indication of what the court may or may not consider. But Your Honor, if you disagree with me,
I disagree with you. I'm telling you that nobody's ever apparently addressed this in any published decision in brought to the court's attention.
Well, I think you're correct in identifying that there's no case directly on point, but the weight of the authority compiled suggests that courts may not consider this information. I'd like to turn quickly to this Birkenfield case, which Chevron cited yesterday and relied on extensively in their brief for the proposition that an initiative could not, voter initiative could not be severed. That's one of the very rare instances, a case from 40 years ago now, in which a court found an initiative was not severable. And the clear distinction in that case is that in Birkenfield, the initiative created and empowered a new rent control board. And the invalid provisions were the restrictions on that board's authority. And the court found that if it were to invalidate those provisions, those restrictions on the board's authority, but leave the remainder of the initiative in place, it would enlarge the board's powers beyond the scope of what the voters had contemplated when they voted in favor of the initiative. In striking contrast with Measure Z, we have 3 land use measures, and if all serving environmentally protected goals, if the court here were to rule that one or more of those 3 measures were invalid for any number of constitutional reasons, the voters' goals would, the voters' ability to accomplish their goals would be narrow, not enlarged. just narrowed beyond the contemplation of the voters. And that's exactly the situation that we see in California Steelmakers Association, where an initiative contained 2 environmentally protected goals. The court struck one of them and said, look, voters were trying to achieve these environmentally protected goals. They can't do both of these things, but at least they can do one of them. So I'd like to turn quickly, that covers volitional severability. I'd like to turn pretty quickly to the question of functional and grammatical severability. And this wasn't briefed extensively by the plaintiffs, but I saw that Aera has now argued that the measures are functionally and grammatically inseparable. And the question here is whether the provisions are capable of independent application or whether they're inextricably connected. And Measure Z's 3 land use provisions are separate land use policies. They're each fully self-contained and discrete. They contain their own definitions, and they don't cross-reference one another. So the court can pull one of those initiatives, or one of those policies, excuse me, if it must, without affecting the implementation of the other 2 policies.
You want to talk about the interplay between the well stimulation treatment provision and the no new drilling provision?
I'd love to. So I wonder if we could start with a hypothetical, and that is that one of those provisions is found to be inseparable. Excuse me, found to be valid. So we're dealing here with the no new wells provision, and did you say the well stimulation treatment provision?
Assume well stimulation treatment is it's invalid because it's and further assume that the position taken by your co-counsel and by interveners is that no new wells means no new wells. And that means no additional steam injection wells. Even if the evidence is that one cannot continue existing operations without the addition of new steam injection wells. So, assume that the provision, the prohibition against new wells includes no new steam injection wells, and steam injection wells were off limits because the prohibition was preempted. What happens with respect to the no new wells portion of measures?
So just to make sure I understand the courts correctly, we're talking about a circumstance in which the no new wells provision is invalid.
No. I'm asking you what happens in terms of severability if the well stimulation treatment portion is found to be preempted. And well stimulation treatment and the second and the third section, the no new well drilling prohibition is deemed to be so broad as it seems to be, as to preclude any new steam injection. So that one could not literally enforce or allow the no new drilling prohibition to stand. What happens to that no new well drilling prohibition section? You follow where I'm going?
Let me just spit it back to you, just to make sure. I think I do, Your Honor. We're under a circumstance where we're adopting intervener's position, which again, we believe this initiative is clear on its face. No new wells means you can't poke a new hole in the ground. Right?
You cannot.
Cannot.
That's right.
Right? So, and the court finds in the future that the well stimulation treatment provision is preempted.
Correct.
That's not going to work. But the remaining two provisions, the prohibition on wastewater injection and impoundment, and the prohibition on new wells, remain in effect, or would if the court finds them to be severable. So we're assuming that one out of the three provisions is held to be unconstitutional.
Invalid for whatever reason.
Under the state or federal constitution. Okay. So, and I appreciate your patience with me on this hypothetical here.
This is not a simple area of question.
So the well stimulation treatment provision is preempted in this hypothetical. The new wells provision and the prohibition on wastewater injection can remain, because the well stimulation treatment prohibition will no longer be in effect. That means that existing wells can be subjected to well stimulation treatment,
Including the drilling of new steam injection necessary for them to be operated, or wetter injection to dispose of produced water.
No, Your Honor. This steam injection is different than well stimulation treatments. I think.
I'm sorry. I'm sorry. I understand your confusion. I mischaracterized it. I'm talking about the injection and impoundment section, not the stimulation. Well, stimulation treatment is so-called fracking portion.
Correct.
So certain segments, which is the prohibition on underground injection and impoundment. I'm sorry, I can see why that would be confusing. If the prohibition on underground injection and impoundment is found to be preempted, underground injection of necessity includes drilling new steam injection wells and drilling new disposal wells. What happens if the third prong measures the prohibition against drilling any new wells whatsoever?
So again, just to make sure I understand you entirely correctly, we're in a world where the wastewater injection and impoundment provision is preempted, but the new well prohibition remains on the books. Is that correct?
Maybe that's the question.
Okay. The voters have spoken, and they've said that they don't want new holes in the ground. And the county, the court might find that the county is prohibited from preventing parties from using wastewater injection in existing wells pursuant to Measure Z. But if that provision is found to be invalid, then the parties can, the oil and gas industry can continue using wastewater injection on existing wells, but not on additional wells.
So you can drill new wells in the ground.
No, Your Honor.
If the court determines that there's no way that the underground injection preemption can be anything but preemptive, and that requires allowing steam injection and wastewater disposal injection you see any way that the no new well prohibition can remain?
I think that the court is describing a situation in which it believes that the state preemption clause gives owner-operators a right to affirmatively drill wells wherever it wants to.
No. No.
Drill as many wells as it decides that it needs to in order to conduct the activities that it says are necessary for its continued economic development of this oil field. And I think, Your Honor, that gets away from the preemption question, the question of whether or not localities can actually govern this question and address this question.
Well, we already talked about preemption. I'm asking you to assume. I want to know what your position is about where it goes if underground injection and wastewater impoundment prohibitions are preempted. Is there any way that the prohibition on drilling any new well, any wells, for the purpose of recovery or aiding in the recovery of, the language is very broad, oil and gas resources, is there any way that no new wells prohibition can stand if the underground injection and the power portion goes because it's preempted?
Yes, Your Honor. So here's how. The court determines that the wastewater injection prohibition is preempted, and an owner-operator seeks to drill a new well in order to inject wastewater. And the new well is prohibited by Measure Z's land use policy prohibiting new wells, but the owner-operator applies for an exemption from the county on the grounds that it has a vested right and is permitted.
You're taking this way beyond the scope of the question. All I want to know is there any way if the underground injection and wastewater impoundment prohibition portion falls because it's preempted? Is there any way that no new drilling prohibition can stand?
I'm going to answer your question in two parts, Your Honor, and the first part may seem a little oblique, so I don't want you to think that I'm avoiding your question. But the first response is that I think that because we're grappling with this hypothetical for a while now, that makes it somewhat clear that a lot of this determination, the severability determination, will rest on the nature of the court's finding with respect to any preemption or other takings determination. And so we request additional briefing, Your Honor, on limited to the issue of severability once we have the benefit of the reasoning behind any decision by this court to invalidate. And that way we can more productively address your questions. But to actually address the question, I think, I'll put it as simply as I can. I think if, Your Honor, you find both that wastewater injection prohibition is preempted and that preemption, the grounds for that preemption is so broad that it includes a right to poke new holes in the ground to conduct wastewater injection, that right is guaranteed by the state, then no, Your Honor, I don't think that those two provisions can coexist. Certainly.
Now, what about the fracking portion? if those two fall, can the fracking prohibition stand? And that's part of why I asked you about what the court can consider in determining pollution severability. Clearly, there are endless photographs of people holding up Measure Z signs that mention fracking and nothing else, basically. So, what happens to the fracking provision? The well stimulation treatment provision.
Sure. So is the question here, just to make sure I understand, we're going to a hypothetical now, where the well stimulation treatment provision is found to be, say, preemptive.
No, if it's not, if the court doesn't get there.
Yeah. So
For instance, suppose the court found that there was nobody here with standing to raise that.
I see. So, as I understand it, we're in a world where the well stimulation treatment provision, the fracking provision, is the only provision that the court has found to be potentially valid. In other words, not invalid, not
Or at
preemptive.
least not found to be preemptive.
So
Not found to be invalid.
can the well stimulation treatment stand on its own? Is the question? Yes, I believe it can. And Your Honor, I think we've been grappling with this under the rubric of functional severability, in which we're looking at the interplay of one provision on another. So the well stimulation treatment provision can stand on its own because it doesn't affect, well, if there's nothing else there to conflict with. I don't see what the basis for conflict would be. Right? If it's just out there standing alone and there's no associated prohibition on new wells,
Correct. Assuming that well stimulation treatment prohibition is not found to be invalid in this proceeding, can that stand in the absence of the other two provisions prohibiting injection and no return?
yes, it can, because it's both volitionally severable and functionally severable. So it's not inextricably entangled with the other two provisions, such that removing those two provisions makes it unworkable in practice. And it's volitionally severable because it would achieve some substantial purpose of what the voters intended, even if not the full purpose.
And it did expressly carve out injection, steam injection, from the definition of well stimulation treatment.
Yes, Your Honor, it carved out steam flooding. And again, it follows accepted state definitions. So these distinctions have already been in practice in California for some time now. And I think, Your Honor, you might be consulting page 127 of the administrative record.
Well, I've got my own copy here. So, but basically, the provision says well stimulation treatments means, and then it says well stimulation treatments include, and then it says well stimulation treatments do not include steam flooding, water flooding, or cycled steam.
Correct, and do not include routine well stimulation work, well maintenance, etc.
So does that support the severability notion that this provision can stand on its own if the other two do?
Yes, it can. All three provisions, our point is that any collection of one or two of these provisions can stand alone. But if we're talking about the fracking provision, and yes, it certainly can stand alone because it's both volitionally and functionally severable. Just very, very briefly now, I want to address the...
For a moment, How's the court order? Normally, I've taken a break about 10 minutes ago. Do you want to take a recess?
About 2 more minutes at tops.
All right.
Is that okay? Great. Thank you. So I just want to address Aera's argument that language from Section 7 and Section 8 of the initiative cause these three policies to be inextricably intertwined with each other. I just want to point out that Section 7 is an implementation section, and it's basically just a housekeeping provision that tells the Board of Supervisors where to put these three land use policies. You got to stick them in the general plan. You have to put them in the local coastal program, which serves as the general plan for a particular area of Monterey County, etc. It doesn't mean that the policies themselves are functionally entangled. And they've also latched on to language in Section 8 saying that the measure is a comprehensive measure, and this is on AR page 139. And the title of that provision is Effective Competing or Alternative Measure on the Same Ballot. And this is a defensive provision that's included in a lot of initiatives. It simply addresses the increasingly common case in which opponents of an initiative will put a watered-down version of the same initiative on the ballot in order to get more votes. And so that provision does address the question of functional entanglement. Unless the court has any further questions, I think that concludes my remarks.
I don't. Thank you.
Thank you.
We'll recess for 15 minutes.
Remain seated, come to order. Court is again in session.
Back on the record. Ladies and
Good afternoon, Judge Willis. I am going to be presenting a rebuttal argument for all the...
I'll use an amplification. If you press it so the green light comes
There we go. Yes, Your Honor.
It's highly executive.
Good afternoon, Judge Willis. I'm going to be presenting the rebuttal for all the plaintiffs.
Okay.
And I'd like to start back where I ended. Very clear in California, the local subsurface regulation of oil and gas operations and activities is preemptive. And I started my presentation yesterday. Seems like a long time ago. with the basics that regulation of subsurface techniques is preempted. The AG opinion, Attorney General opinion in 1976 makes that very clear. And as the court noted, the interveners in particular, but also the county, ignored all of this express, clear statements by the Attorney General. Here's one where it said that if the locality seeks to regulate for a local purpose, but directly or indirectly attempts to exercise control over subsurface activities, that's preempted. There's also the interveners, they emphasized, came up with a new interpretation that suggested that that there was just a minor, some technical restriction, that if it was technical, then there was no preemption of subsurface activities. Clearly, technical activities are preempted, but here, this is on page 462, Your Honor, of the Attorney General opinion. After saying that subsurface activities are preempted, this is top of page 462. The Attorney General says, particularly where state regulation approves of or specifies plans of operation, methods, materials, procedures, equipment to be used by the well operator, or where activities are to be carried out under the direction of the supervisor, there is no room for local regulation. And counsel, you asked about that no room for local regulation. Here's another place where it said that literally the no room for local regulation. Nothing in there about some hyper-technical requirements. It's a broad statement of preemption. The other part of the Attorney General's opinion I wanted to highlight is that in my slide 4, the Attorney General declared that state statutory and administrative provisions appear to occupy fully the underground phases of oil and gas activity. And so there it's talking about the statutes and the regulations. And I think that it's really glaring, Your Honor, that the interveners in particular today have run away from their concessions in their brief. Because it couldn't be clearer. If I can go to slide 7 from my original presentation. This would slide, let's see, this is the quote from DOGGR in the EIR, where DOGGR declared that it has exclusive legal jurisdiction over and thus occupies the field regarding subsurface regulation. And this means that no other state or local entities can regulate. The interveners agreed expressly with that in their brief. They declared, and this is on slide 45. Let me just give you this one, if we can. I have this in my original presentation. Maureen, if we could, maybe just, I'll just read it to you, Your Honor. It's not magic to put it up. Here's what they said in their original brief. After I go back, they quoted the language from the EIR where DOGGR in 2015, this is an ancient history, relying on the AG opinion, the agency that gets deference. They quoted the language from there saying, the very specific requirements of SB4 itself are so detailed they simply leave no room for local governments to add further downhole requirements.
When you say they quoted, you're referring to?
Yes, they were addressing this exact language. And then here's what they said about it. This characterization, this is on page 35 of their brief, this characterization simply underscores that DOGGR's oversight under SB4, just as it has historically been, is focused on downhole requirements, and interveners do not dispute that a local government cannot layer conflicting downhole requirements on top of these state requirements. That's a concession, it's an admission, and it can't get around it.
What about the reference from Ms. Fletcher to their exhibit number L in the request for judicial notice, this February 8, 2017 letter from Department of Gas and Geothermal Resources?
Yes, Your Honor, I was going to address that, and I'll do it right now. If you read the whole letter, it tells a completely different story. Well, not completely different. It tells a different story, and certainly doesn't have anything to do with preemption. First, the division supervisor who wrote the letter is responding to a letter from the county, or from the proponents, I believe, of the initiative, claiming that Measure Z basically preempted the DOGGR and the Water Board from seeking an aquifer exemption from the EPA. So they were saying, Measure Z, you can't even do it. That shows how broadly they are interpreting their authority against Measure Z. They're basically saying Measure Z preempts. And the division says, no, Measure Z does not prohibit us from going and getting an aquifer exemption under the Safe Drinking Water Act. And we have the authority to do that. Furthermore, in the last sentence of the second paragraph, the division notes that there's a stay, there was a stipulated stay, that's anticipated to remain in effect until the judicial process resolves questions surrounding the legality of Measure Z. So it's against the backdrop of the fact that the division knows we're in court arguing about preemption. And then it's a polite, diplomatic response saying, nothing we're doing with the exemption aquifer process takes away your right under Measure Z to take whatever positions you care to take. And that's against the legal backdrop of this preemption argument. And it's against the backdrop of the division in the SB4 EIR unequivocally, clearly stating that SB4 has a preemptive effect on whole downhole requirements. If we go back to the prior slide, I think that was the SB4. Go one back, please. Well, we'll get to it. But and that's maybe, I'll just briefly on that, while we're talking about preemption. The court, I think, is all over this, but the letter from Senator Pavley after the bill was passed, the California Supreme Court has said many, many times that sort of statement by a single legislator is not entitled to judicial notice, let alone admissible as evidence, and it's not, it carries no weight. one of the cases we've cited is that the Quintano v. Mercury casualty case. It's at 11 Cal 4th, 1049, and it's footnote 5. And there the court notes this is a frequently stated proposition. So, Your Honor, I want to get to this question. So, of what is a downhole activity? As I said at the outset, really the main question here is, what does it mean to regulate a downhole activity? And if we look at, first, Mr. Tanaka yesterday declared that everything in San Ardo is downhole. And that was what he said during his argument, and he's right. We're talking about drilling wells under the ground, well stimulation, and that's stimulating the well under the ground in order to make the earth and the formation more permeable to get oil out, and underground injection. It's all downhole, as Mr. Tanaka noted. The county interveners literally are asking the court to say that what's down is up, because some of the activities are on the surface. And Mr. Tanaka came up with a new term even yesterday, downhole implications, which that was, I don't remember that from earlier, that in the position that he articulated yesterday was that the county can regulate things that have downhole implications if they're regulating the surface. But Measure Z does more than regulate things that have downhole implications. It drills down into the ground and it regulates directly fundamental, crucial operations below the surface that tie the entire operation together, and without which there can be no oil operations at San Ardo Field. And on that front, Measure Z doesn't target traffic or noise or the number of trucks that can come in and out, or fencing, or anything like that, traditional sort of land use type of things. It goes for the jugular. It goes for the regulatory jugular, well stimulation, hotly contested issue that the legislature looked at with everybody being heard from and decided well stimulation should be encouraged and allowed. Underground injection, subject of intricate federal and state partnership and laws and regulation, and the drilling of wells, which is squarely within DOGGR's authority, heavily regulated. Permits have to be issued, approvals have to be issued. So this is not, by any measure, simply traditional land use. It's far outside the traditional land use regulation. Yes, sir?
How do you reconcile that Beverly Oil case?
Just going to get to that, Your Honor. You're reading my mind here. And first, on Beverly Oil, let me start with the fact that in Mr. Tanaka's presentation, he had emphasized that, or suggested that the Attorney General's opinion had adopted and had suggested that the land use opinions like Beverly Oil had endorsed the notion of no preemption of the kind of activity, so that they were a launching pad for that. But I'd like to show the court rebuttal slide number 9, because this takes the wind out of the sails there. The Attorney General actually said the opposite. The Attorney General said that the sweeping statements in a number of the cases, and it's basically every one of the pre-1976 cases that anyone cited, that there are sweeping statements that local entities can regulate the manner in which oil and gas operations are carried out, as well as to prohibit such activities. And then he says, as has been said, these cases without exception fail to consider any conflict between local and state authority. No California case deals with the extent of the authority of a city or county to regulate the manner of carrying out oil and gas operations once that county or city permitted the area in question to be used for oil and gas extraction. And then he went on to basically say that the language was about the scope of the authority was unnecessary because there wasn't any preemption issue there, and said, I'll talk about these cases, but they don't help us answer the question. That leads me into Beverly Oil, because Mr. Tanaka and the interveners, they've banked a lot on Beverly Oil, which Mr. Tanaka showed a page from the Attorney General's opinion and said that the Attorney General had said that what was opined that was allowable under Beverly Oil, that would not have been preempted, even though it was not a preemption case. But in fact, right before the place that Mr. Tanaka was pointing to, and this is the next slide, the Attorney General, let's go to the next slide. This is what was the lead-in to the analysis. This was the appendix to the opinion of the Attorney General that Mr. Tanaka was pointing to. And the Attorney General said, I can't express a firm opinion on whether these specific provisions have been preempted by state law. This is for illustration purposes only. The codes, the information is not complete. I'd have to look at the whole thing. So they walked through the appendix, but affirmatively said, we're not opining on that. So this court, of course, has ample ability itself to take a look at Beverly Oil again and decide for itself. But Beverly Oil and the other cases cited from those early years really just begged the question. And this court suggested that yesterday, at least pointed to this fact. The question is whether, if the county has the police power, they're not doing anything beyond their police power to pass the law in this area, then the question is it preempted by state and federal law? Is there a superior law that says that it can't take it back or it has no effect? And there's been simply no answer to that question. They just keep hammering that these cases said that in zoning, restrictions could be made in designated areas or a small city like Hermosa Beach that had never allowed gas production, that they could restrict those activities in those areas as a matter of police power. But none of them, other than the Higgins case, which I'll come back to one more time, talk about preemption. Moreover, the law, as I said, Beverly Oil was not a preemption case. I think counsel for the intervener actually used the word that the court there found preemption, or found no preemption. The court did not. It was not a preemption case. And actually, in Beverly Oil, there was it's an old case. It's 1959. It was before we had the amendment to Section 3106 in 1961 that added the provision I like so much. We can go to the next slide or two. Continue. Next one. So Section 3106B that I have cited many times, that the interveners seem to think is irrelevant. It's not irrelevant. It's directly relevant and indicates the state policy of encouraging exactly the activities that are at issue here. But Beverly Oil didn't have this, and the court didn't have this to analyze. Likewise, subsection D, which was discussed, and then more from subsection B before I get there. The policy of this state is stated now in 3106 subsection B. And I guess while I'm talking about it, before I move on from this provision, the court, I think, was focusing on the language. This doesn't just say, it's not a requirement of prudence and reasonableness. It's not telling, it's not a safety provision or something like that. It's saying that the policy of the state is to allow an operator to do what a prudent operator would do. And the other provision, the next provision, also says that it's basically any reasonable practice in policy. So this wasn't, and the language, it's actually not in my quote. We have the quote that the court's very familiar with by now. It affirmatively says that it's a contract is deemed to allow. That's mandating. That's saying this operator state law says this operator can do these things. The injection of air, gas, water, application of heat, and all for the reduction of viscosity of hydrocarbons. That's not some offhand suggestion, and it's nothing like what the interveners were describing. the language is deemed to allow the lessee or contractor to do these things. So it's a strong, firmly stronger than Section 3700 regarding geothermal resources, for sure, which doesn't say any of these things. This is affirmative, clear, encouragement, policy of the state to allow what is happening in San Ardo Field, including the steam flooding, the drilling of the new wells that's essential to that, and all the other activities to allow the oil to be brought out of the ground at that location. On Beverly Oil, there were other developments. We had obviously SB4, Beverly Oil didn't have that in front of it. The State Drinking Water Act and the primacy given to the state, that hadn't happened. So it's a completely different landscape. But Beverly Oil also is easily distinguishable on the facts. I should note the photograph, I can authenticate it, it's Mr. Klein when he was a child at what was then called Ponyland in that area right where the oil wells are. I hope I didn't overstep my boundaries here on the evidence code, but this was in the middle and there's oil wells still pumping there. So it's, as the court says here, it's light industrial development, but immediately surrounded by dense residential development in the middle of Los Angeles. And there's some commercial development, but there was also kiddie land. It was a residential place where people were taking their children, and Los Angeles then enacted a zoning ordinance that said there could be drilling in some zones, but not in this zone. And one of the operators challenged it. And that operator was pretty successful. They're still pumping oil from that area. The court in Beverly Oil held that only that there was no unreasonable, oppressive, or unwarranted interference with property rights. So that didn't have anything to do with preemption. And then the court did mention Section 3400, but in passing, as it was explaining why, there was no real, not a taking, not an elimination of property rights, because the operator actually benefited by the operation of the ordinance. Basically gave the operator a monopoly because he was the only one that was allowed to keep functioning, pumping oil, including the oil around him from his neighbors. So the court said the variance places the plaintiff in a position which is highly favorable, and therefore there was no constitutional or other violation. I don't see how that case helps the interveners or county here, let alone it's the linchpin of their argument. Not a preemption case, highly favorable, whereas as we've demonstrated, Measure Z is totally different. It's a sweeping, county-wide regulation of techniques and operations. It's not a ban on oil operations. It's a regulatory provision that literally burrows down under the ground and regulates. The Higgins case that was discussed, I think, by both county and interveners, or mentioned, is the only case that had a preemption issue. Mr. Tanaka suggested in response to one of the court's questions that this case supported them because the Supreme Court in that case, in 1964, looked at all of the provisions like Section 3106 and all the regulatory framework and determined that there could be a restriction on the city, or the city could preclude by voter initiative or otherwise oil drilling on tidelands that were granted to the city by the state. But that's incorrect. The court did not look at 3106 or the broad framework. All it looked at were the specific, in its words, permissive provisions of the Public Resources Code that dealt specifically with the issue of the city's ability to control the lands given to it by the state. And then it went on to say, however, that if the city had tried to regulate the mode and manner, that's what we're talking about with Measure Z, the mode and manner in which the city executed oil leases, that would be preempted, because that was covered by state law that mandated certain things happen before those leases could be entered into. The Hermosa Beach case, that's the most recent case, but again, it has little or nothing to do with the issues we're presented with here. Not a preemption case. The way it arose, Your Honor, it Hermosa Beach, again, does not look anything like San Ardo Field or the area surrounding it. In Hermosa Beach, it's a small residential city with no industrial area, virtually all light commercial and residential uses. No oil operations had been allowed there since 1932. 60 years later, the city decided it would go lease some of its tide lines, much like the Higgins case. But then the voters voted no, that the prohibition should go back into effect. And the lessee complained that that defeated their contractual rights, the constitutional matter and otherwise. And that was the only issue. And the Court of Appeal there said under the specific facts, there was no violation. So these cases, the land use cases, that's like step one of the analysis. And the interveners in the county are acting like game, set, match. I'm mixing my metaphors. That they decided. They don't. They don't tell us anything other than let's now apply preemption principles. And the situation, as I said here, is completely different in those cases, where we've had oil operations going on since 1949, permitted by the county, then subject to a dragnet of regulations and statutes from the state, from the federal government. Permits have been granted for projects, for well drilling, and huge investments in the property. So it's nothing like these cases. So to try to avoid preemption, the counties and interveners are asking the court to do a number of things. First, to ignore and contort the language of Measure Z, to read new regulatory definitions and requirements into the measure, and they don't even agree on all the specifics. So the county says replacement wells can be added once others have been abandoned. The interveners, the proponents of the initiative say, no, absolutely not. And so they're respectfully, I submit, twisting or expanding the language of Measure Z in ways that just defy normal principles of statutory initiative construction. Those efforts don't help them. They actually show why Measure Z is preempted. Let's go to the ban on well stimulation, Your Honor. So, see, go back one slide, please. Let me just go through myself here. Let me go back to the next slide. I want to, so as the court knows on well stimulation, you raised it today, and I had raised it yesterday, the question of acid maintenance. And the county is now taking the position, I believe, that even though there's this vagary and gap in terms of trying to determine what acid maintenance is, as opposed to acid stimulation, that can be solved by looking to DOGGR's regulations, which, as I said yesterday, that shows duplication. That shows that they're treading into DOGGR's territory. They're going into the division's exclusive realm and trying to borrow their definitions. And here's my question. If they do that, who's going to decide these issues? So the regulation from DOGGR, section 1761 of the Code of Regulations that I have up on the screen, first of all, it only creates a presumption if the operator shows that their acid maintenance if it meets the acid volume threshold. If it becomes below the one that would put you into the well stimulation realm. But then the operator has to demonstrate to the division that this is not an enhancement of oil permeability and well stimulation. So there's still a set, they have to show DOGGR what they're going to do. In the Tubbs declaration, Mr. Tubbs noted that, it's paragraph 53, that there's no way to tell. There's no other than what DOGGR says, and Mr. Burzlap, the expert for the county, and we cited this in our reply brief and in the trio brief, he said there wasn't anything in the measure, and then that's what DOGGR deals with. So there's a duplicative regulatory regime. And then what would happen if DOGGR said one thing, the county said, no, we don't accept that. We're going to go another way.
Can't it be construed as Measure C to accommodate the determinations made by DOGGR regarding what the appropriate threshold level is and whether or not the presumption is overcome for the satisfaction of the provision of oil, gas, and geothermal resources? Can it not be saved by simply saying that county, in enforcing that particular section of Measure C, must abide by DOGGR's determination?
Well, that would address this question, but it doesn't resolve, it would resolve if the court were to read that into the measure. I think from an interpretive standpoint, that's quite a leap, that the voters would never have known anything about that. And there's nothing about that in the, even if you just look at ballot materials, and there were no signs that people were carrying around that said, you know, anything about this. So they would not have known about this. So it's quite a leap. It would fill in that gap, but then we have this situation where to save, I guess save it in the sense that it wouldn't have this, cause this problem for Chevron and others. It would be saying DOGGR has the responsibility here. Getting back to the preemption issue, DOGGR is the one who decides these issues. And let me show you, Your Honor, I've got the formula that DOGGR applies. Please don't ask me any questions about it. This is their, how they determine, look at the formula ABT equals. This is the acid volume threshold that DOGGR applies. And I could not apply that. I'm a big fan of the County of Monterey. I doubt that they have people ready to go apply that. And as the court suggested, well, what if we just say this is up to DOGGR and the county, this court would have to abide by what DOGGR says. But that proves the point. This is highly regulated territory, complicated territory. It's not just technical, it's engineering, it's chemistry, and we've got a system. We've got the strongest regulations and most rigorous environmental and safety regulations administered by the state on precisely these issues. So there's no need to read those issues into to try to read things into Measure Z. And there, in terms of well, I'll leave it at that on the acid maintenance and stimulation. I think that it clearly would have an immediate effect on the operators, and the effort to read into Measure Z these highly complex formulas into Measure Z demonstrates that Measure Z has crossed the boundary into below ground regulation that's the exclusive territory of DOGGR. With respect to the ban on underground injection of produced water and impoundment of water, section 1.22. The county and the interveners have no answer to section 3106. I won't spend a lot of time on this because I already got to it. They're just ignoring what it actually says. It's an unusual provision. The timber harvest statute that was at issue in Big Creek Lumber, it didn't have things that said the policy of the state is to allow and redeem that operators can do certain things as a matter of state law. And this goes right to the underground injection of water expressly. It's the policy of the state. If it's reasonable to improve methods approved by the supervisor, the division of oil, gas, and geothermal resources, then it must be allowed. It's all in the name of producing and encouraging the wise development oil and other hydrocarbons. So we have about the most explicit language, and as I mentioned yesterday, the policy is to allow all methods to increase production. Now, granted, after Beverly Oil, the provisions were put in that gave DOGGR even broader responsibilities, as my colleague yesterday mentioned, to look after the environment, to look after safety, to protect the environment, to protect our natural resources. They've got a lot of responsibilities, but it's exclusive jurisdiction that they wield when we're talking about the underground authority, and neither the county nor the interveners really have been able to deal with this issue. Section 3106, Your Honor, we submit on its own, preempts, Measure Z's prohibition on underground injection of water and other produced water. But the Safe Drinking Water Act is the icing on the cake, so to speak. The court, I can tell, knows it well and has studied these issues, so I won't belabor the point. But this provision actually has the word brine in it, the underground injection of brine or other fluids. That's exactly what Measure Z is banning, unequivocally, even with all the concessions and the running for the hills and the meaning of Measure Z. Both the county and the interveners say, well, injection of brine for disposal is prohibited. And Your Honor, you'll remember the brine is the substance, the water that comes out after the
reverse.
Exactly. And yesterday, Ms. Fletcher suggested that she had a solution, that you could just truck it on out and everything would be fine. Or there might be some new technology, but the problem with that is there's one, as the court pointed out in this question, there's no evidence that, in fact, the evidence is all to the contrary. Our declarations from Mr. Latham and Mr. Tubbs point out that it would cripple production if you had to put the water in trucks. It would basically double the number of trucks going in and out, which seems inconsistent with the supposed land use process. The need to dispose of the water is crucial for this to function, the operation to function. And I believe it's something like 153 million gallons of this water. This is just the 25% of the 25% of the water that goes through the reverse osmosis process. And going back to the prior slide with the language again, federal policy that has been enshrined onto our state system says that underground injection control programs may not prescribe requirements which interfere with or impede the underground injection of brine or other fluids which are brought to the surface in connection with oil, unless that's essential to protect underground sources of drinking water. The position of the county interveners, well, to adhere to this policy, you can just ban the injection of these fluids. Well, that flies right in the face of this policy, this statute, and that's what the umbrella over our state policy, our underground injection program. And it wasn't some offhand, again, remark. Congress was clearly balancing the super important interest in protecting our drinking water with the other very important interest in energy independence, oil production, and the like. It's stated in the legislative history as well, explicitly. The legislative history says that proper interpretation of the statute, the Safe Drinking Water Act, is to prevent endangering underground water resources while not imposing unnecessary requirements which would impede or interfere with oil or gas production. In the face of that, Mr. Tanaka and the interveners say, well, the county can just ban it. They can ban the injection of water, even though the record before the court is undisputed that would impede, it would interfere, it would pretty much wipe out oil production at San Ardo Field. That is preemption. And then, on top of that, we have the detailed regulations that DOGGR has promulgated, the permits that have to be obtained in order to inject water, to inject into the ground. It's a rigorous system that occupies the field. One of the reasons, Your Honor, that, and this again goes to questions you were asking both the county and the interveners, this notion that the state, I believe Mr. Tanaka said yesterday, he admitted that the determination of whether restrictions are essential to protect the water, that's something that the EPA or the state, and the state make, and the state here has primacy. So here, how in the world could it be that the county can then say, I don't care about that, we're just going to ban it? And courts have looked at this in different contexts. The 10th Circuit in the Blue Circle cement case, for example, talked about this under the RCRA, the statute. It's really an analogous statute to, say, the Drinking Water Act. It's the Resource Conservation and Recovery Act. It's a similar statutory framework. We cited this in both our briefs for Chevron, regarding it's a federal-state partnership for disposal of hazardous waste. And here, the Safe Drinking Water Act is concerned with the disposal of wastewater in this context. There's a savings clause in that case, in that statute, that allows for more stringent local regulation and allows local authorities to regulate. But the 10th Circuit said that may be true, but if they outright ban it, then RCRA would preempt the local regulation, because it would basically cripple the regulatory regime. The Blue Circle Cement Court also noted that if, in fact, that was permissible, that local authorities could just ban the hazardous waste disposal in their county, then everyone could do it. Other counties could do it. And this takes me back to yesterday afternoon when this court noted or asked, and want to put decisions in the courts, attribute things to the court, but the court asked the question about, well, if there's a ban on brine and it has to be trucked out of Monterey, where does it go? It goes to some other county, it goes somewhere else in the state, and that makes it an issue of statewide concern, particularly if other counties could also ban this, and then it would be either a ripple effect, or other counties would be affected by the activities from the county of Monterey. That's why these issues are of statewide concern. During their arguments, I think both county interveners mentioned the Bath case. This court put its finger on the fact that that was not a ban. It was just additional regulation. And in that case, in Bath, the state had not taken primacy. So it's just a very different situation. We've cited the district court's decision in the EQT case, another federal district court decision that did involve a local ban. And this is back under the Safe Drinking Water Act. And there, the district court said, much like Blue Circle Cement, you may be able to regulate it more if you're a locality, but you can't ban it. That defeats the purpose of the statute.
In the Fourth Circuit, no pun intended, watered that down a little bit.
Yes, they did. Affirmed on other grounds and said, I think basically that state law would have precluded that sort of ban, which is what we argue here too as well under Section 3106, but you're exactly right. Finally, the court's colloquy yesterday with Mr. Tanaka about the meaning of storage and disposal shows why Measure Z is preempted. I think it was a valiant try by Mr. Tanaka to redefine those terms and come up with something that isn't storage and isn't disposal. I don't think it hangs together. I don't think there's any support for it. There's no support for it in Measure Z. There's no support for it in the dictionary. There's no support for it in the history of Measure Z or in any of the oil and gas glossaries that exist. It was very confusing, but it shows the problem here. Mr. Tanaka, excellent lawyer, is doing his best to come up with new regulatory terms that the county presumably would apply or endorse at some point, and then they would become the mini division of oil and gas. And they would be applying these new terms and regulating this underground activity. That is preempted. And just to give one example, on the storage point, the court and Mr. Tanaka were going back and forth about storage. And Mr. Tanaka said that the steam chest is not stored water. Of course it is. A chest, just the definition of a chest, you put something in a chest until you need it again, and you take it out. And the fact that some of the water comes back out and it's produced again after it's no longer steam, it comes back out, that is the definition. I mean, when we store things, there's a suggestion we may take it back out again. It's stored underneath the ground. It's maintained underneath the ground. And as the court pointed out yesterday, not all of it comes back out. So that means it's been disposed of. So plain language, plain English, meaning that this law, Measure Z, is banning storage and disposal of water underneath the ground in flat violation of the federal mandate and underground injection program of California. The bottom line is this, Your Honor, that the county's defining and redefining of terms and restrictions and requirements is the essence of underground regulation that's preempted. Finally, Your Honor, in terms of Measure Z, the ban on drilling of new wells. New wells means new wells. I think I heard the interviewers basically say the same thing today. The county, in trying to save Measure Z, departs from the plain text and is making ad hoc new regulations with new interpretations that contradict what the voters were told. There's nothing in the measure that says replacement wells can be added. We appreciate the change, but it's not in there. The county's own expert, Mr. Burzlaff, agrees. We cited his testimony in our reply brief and the trio reply brief. The interveners agree. But as this court knows, the drilling of new wells, injection and disposal, and production wells is essential to the underground injection program and the steam flooding into the entire operation. And as the court, I think, has got it down better than I do probably, but the production wells play an important role here too. So you need the injection wells to keep spreading the steam chest out. You need the disposal wells in order to dispose of the water that could not otherwise economically, in a feasible way, be disposed of, that would allow you to continue. And then the production wells at the outer edges perform two functions. They're producing oil and water flowing out of the ground, but they're pumping out water that otherwise would be there to create pressure, which then doesn't let the steam come in and heat the oil, and also it creates the problem, the water cools the steam chest. And that's why Mr. Tubbs, in his declaration, made very clear that, this is slide 28, Tubbs Declaration 47, that drilling new wells and adding horizontal wells, which are new wells as well, at the perimeter is necessary to avoid cooling the steam chest and to avoid the collapse of the steam chest through the encroachment of that water within the formation. And here, again, there's no evidence from the other side. Mr. Tanaka suggested, well, if you can replace the wells, you don't have a problem. But there's no evidence of that. The declarations from Mr. Tubbs, from Mr. Latham say we have to have new wells, drill new wells in different places, out perimeter, or the entire operation can't function. And it's a situation where we have, the division has regulated this. These are permitted projects with the state saying, it's under the state authority, color of state law, that Chevron and Aera on their part of the field can drill these new wells as part of the underground injection program, as part of the steam flooding process. It's all tied together. The Attorney General's opinion, I promise not to mention the Attorney General's opinion again. I'm almost done. But I come back to this, and I feel compelled to because of the effort to by the other side to say that this opinion means something it doesn't. It broadly states that where there's a plan of action with respect to a particular well or field, or approval by DOGGR of a transaction at a specified well or field, it's difficult to see how there can be any room for local regulation. Here we have approvals, permits that I showed the court yesterday, approving the steam flooding and injection plan that included a provision that contemplated the drilling of new wells, and then we have permits that approve these new wells that are vital to the underground injection plan and the steam flooding. So, Your Honor, there's no getting around it. Measure Z regulates how to conduct subsurface operations. Mr. Tanaka argued over and over again that Measure Z survives because it does not regulate how oil operations are conducted, but whether they are conducted. And I respectfully submit he's wrong as a matter of law and fact. First, the test that I had relied on in the analysis was from Big Creek Lumber. And you'll know, Your Honor, it's not how and whether, it's how and where. And the California Supreme Court was making a distinction that when a locality designates certain areas that things can occur, that's more classic zoning, and it's not, it wasn't preempted there under the timber law because the regulation went to where harvesting could take place. Here, we're not talking about where, it's everywhere, if it's where at all. But it's not regulating designated areas, as the court knows. If the Measure Z is saying how things can be regulated. That's why this is a matter of fact incorrect. Measure Z is the essence of a regulation that regulates how things can be done. It says you can drill for oil, you can pull oil out of the ground. We're not banning that. What we are telling you is here's how you have to do it. You can't use well stimulation. You can't drill any more new wells. You can't inject water in there. Now they're saying, well, maybe you can do it for steam flooding. You can replace wells. They're telling the companies how to do their work and how to do the activities that are encouraged by the California Public Resources Code. That's what it's all about. It's instructing them on how to do it. And that is preempted under Big Creek Lumber and in many other cases that say you can't frustrate the purposes of the law. And both sides are taking the position unless the law of California, the state, commands that you do it, basically says you must do this, then the county can do anything it wants. But as the court will recall, the City of Riverside case that I talked about yesterday, where the court said local governments, even if they have some regulatory authority, and that would include some land use authority, may not wholly exclude activities that are sanctioned or encouraged by state law. That's exactly what Measure Z does. It excludes well stimulation that's allowed under SB 4 and encouraged. It excludes the drilling of new oil wells, which is encouraged and permitted and approved by DOGGR. It excludes the underground injection of produced water. And Justice Liu elaborated on that in his concurrence. He explained what the court was talking about even further. Because this is the exact theory that the county and interveners have. Well, you could comply with both if you just packed up your operations and went home. You wouldn't be violating state law, and you wouldn't be violating Measure Z, so everything's okay. But as Justice Liu points out, that's not the right analysis. It's whether the local law prohibits an activity that state or federal law intends to promote, and that's preempted, even though you could avoid conflict in a sense by just stopping what you're doing, refraining from the activity. And again, going back to yesterday, I think the court asked about it might have even been on this case or the Great Western Shows case that the court was citing in there. Were those cases where the law was promoting the activity? And the answer is no. Both of those cases mentioned, for example, in the City of Riverside, the state wasn't promoting marijuana dispensaries. It was just allowing them to occur as sort of an experiment to a certain extent. And there wasn't a wide web of regulations or anything like that, and the court pointed to that. Great Western shows the same thing. There wasn't a state policy encouraging counties to hold gun shows on their property. It was just, there were state laws about gun shows, and therefore there wasn't preemption. But here, we have these strong policies of the state that encourage, that promote the exact activity that Measure Z is seeking to prohibit. And then maybe I'll just finish up, Your Honor. I think I can do it in maybe 10 minutes. Will that be okay? I'll run a little bit over, just to address a couple of the other specifics. And I think I can be quick. On Section 3690, again, another linchpin of the argument. That was the main thing we heard about in terms of saving Measure Z today. The court hit the nail on the head. It has nothing to do with this case. It doesn't relate to Section 3106. It doesn't relate to the operations. It only relates to that specific chapter on unitization, which literally is all about surface uses of the land. So it's not about underground activity. It's not about oil drilling. It's limited to that chapter. It has no impact on this case. The couple of 10th Circuit cases that interveners cited, claiming that the Safe Drinking Water Act was all only about safe drinking water. They're not preemption cases. The Ardo case and the Phillips Petroleum case, they were just cases where the operators were challenging particular actions and classifications under the Safe Drinking Water Act. So there wasn't any discussion of the issues we're talking about. They really don't have anything to do with what we're talking about. Interveners are confusing express preemption with implied preemption. There were a couple of cases cited in quotes about express preemption. Well, we're not arguing that that either Congress or California have declared we hereby preempt. We're talking about implied preemption and conflict preemption, field preemption based on the intent of the legislature and the comprehensiveness of the regulations. But so Big Creek Lumber, Fiscal, those citations, again, don't really add anything to the inquiry. We also heard about the presumption against preemption. Those cases stand, and the City of Riverside and Big Creek Lumber talk about that, only for matters where the local law is within a traditional zone of authority. And here, it's just not, regulating subsurface activities does not fit the bill, and so there's no presumption against preemption. I might as well finish up briefly on, Your Honor, the severability issue, because I think I heard counsel for the interveners agree, and he can correct me if I'm wrong, that if this court were to find that the underground injection section is preempted, and the court were to find, as we argue, and I think the evidence overwhelmingly shows, that drilling new wells is essential to the underground injection, then there could be no severability. We agree with that. They meet the test for not being severable, both in terms of grammatical and functional tests. They're not capable of independent application. They're part and parcel of each other, and they're inextricably connected. And that's why you can't break them apart. And then finally, Your Honor, you are correct. As far as I know, no one has cited a case that declares that the court cannot consider ballot-related campaign materials like signs if the court makes the basic determinations of relevance and closeness of a connection and feels that it provides relevant information. And I think that we, in our supplemental filing that we'll make tomorrow, 5 pages or less, we'll cite some of the other cases where ballot initiatives courts consider that in looking at the constitutionality of ballot initiatives. And so with that, Your Honor, Measure Z is preempted, and we respectfully request that the court declare it so. Thank you very much.
All right. So tomorrow, we have 2/3 of the day estimated for the
We will definitely try, Your Honor. I'm Barton Thompson. I represent the California Resources Corporation in case 17 CV 0000790. So I'll be starting out with the plaintiffs. My guess is I'll probably forget that.
All right, so, can everybody start at 8:30 tomorrow instead of 9?
Yes, Your Honor.
Sure.
Apparently, I'm confused as to whether or not we have 3 full days left or only 2 and a half.
Well, here's the problem. I had to cover the one motion calendar Friday morning. I have my own one motion calendar I'm covering on breaks, reviewing it on breaks over the noon hour and after hours. It's a fairly large one motion calendar. I anticipate we will go all day tomorrow and all day Thursday. The one motion is Friday. The visiting judge who was going to cover the line motion department next door had a death in his family and cannot be here. I don't know yet whether we've got another judge to cover that. If not, I'm going to have to hear that calendar on top of my own calendar. In any event, I intend to go all day tomorrow and all day Thursday, realizing I may not be able to get through it. And I won't be able to hold this trial on Friday morning. We also have quite a few settlement conferences set for Friday afternoon. I'm going to see what I can do about moving some of those around. We can certainly resume on Monday. There's another writ hearing that's set for Monday, but this case is started, and I do want to get it concluded as soon as we can. So if we spill in to next week, so be it. We'll go all day Monday if we have to. Mr. Snyder?
Your Honor, my partner has a court of appeal who will be arguing this court of appeals argument on Monday. Not here.
And are you going to be arguing a particular section?
I will be arguing, Your Honor, the due process, the single subject, and so any later portions of the issues.
Your Honor, might I suggest that we can get this done? We'll work together to try to get it done by Thursday.
Let's see if we get it done. We'll get it done one way or another.
Great.
Okay. Next Tuesday again, I have a case management calendar. In the morning, it says it today, but we'll go in the afternoon. And I really hope we don't have to do anything. What we do with it.
We'll do our best, Your Honor. We'll talk after the report today to try to sharpen things up.
All right, I'll see you.
Thank you.
Tomorrow. Have a good evening.